Namaskara and welcome to BIC Talks, a podcast brought to you by Bangalore International Centre, where we present conversations that move, inform, and encourage discourse.
See, there are two views in the matter. There is one great aphorism, Latin maxim, which says, do justice, even heavens come down. But Clive Lewis, in his Remedies in Public Law, says, in the modern day complex administrative situations, this rule can't be applied universally. I upheld that passage in a judgment in the Supreme Court. I don't remember which. I said, in the complications of the modern, a little more play at the joints is legitimate and necessary, because it is not some kind of a administrative machine. It's not a logical machine. It's a big bulk of a machine which runs by greed and need. In Law and Society, an author said, is a behemoth which moves by need and greed. It has no contraptions and balances of this thing. It's a beautiful statement saying that governance is not a very logical thing. It runs by exigencies.
Welcome to None Wiser Than the Law, a series of conversations with Justice MN Venkatachaliah covering the law, his life, politics, and the Constitution. The title of this podcast comes from Aristotle, who said, to seek to be wiser than the law is the very thing which is by good laws forbidden. The role of a judge is therefore not to presume wisdom, but to unearth the wisdom of the law. Justice Venkatachaliah quotes this aphorism in a judgment, and in this series, we explore his judicial philosophy that shaped India's jurisprudence. My name is Alok Prasanna Kumar, and I'm a co-founder of the Vidhi Centre for Legal Policy. I had a chance to speak to former Chief Justice of India, MN Venkatachaliah, in August 2023. In our conversation, we covered a range of topics, from his beginnings as a lawyer to his tenure as a Supreme Court judge, his landmark judgments, and his views on developments in law and society. In the first episode, we discussed two landmark judgments delivered by benches headed by Justice Venkatachaliah, namely Kioto Holohan versus Zakiliu and AR Antulay versus RS Nayak. These two cases involved two major political issues that continue to bedevil Indian politics: defections and corruption. In the Antulay case, Justice Venkatachaliyah's judgment says to be wiser than the law is what by good laws is forbidden, and that the well-trodden path is the best path. This captures the essence of Justice Venkatachaliyah's judicial philosophy, as we shall discover in this episode. In Kioto Holohan versus Zakiliu, a constitution bench of the Supreme Court headed by then Chief Justice of India MN Venkatachaliah was concerned with the constitutional validity of the 10th schedule of the Constitution, which had been added in 1985 by the Rajiv Gandhi-led Congress government. The 10th schedule was supposed to reduce political defections, the so-called Ayaram Gayaram phenomenon, where elected representatives switched parties for unsavory reasons. The 10th schedule gave the presiding officers of the union and state legislatures the power to disqualify any member who had switched allegiances from one party to another or who had voted against the party whip on the floor of the House. The 10th schedule was challenged in the Supreme Court as being a violation of the basic features of the Constitution, in that it took away the right of the members to freely speak on behalf of their constituents in the House. Opposing the 10th schedule both in the Parliament and as arguing counsel in court was the late Ram Jethmalani, appearing on behalf of disqualified MPs and MLAs. By a majority of 3-2, the Constitution bench of the Supreme Court upheld the validity of the 10th schedule, only striking down the one clause which said that the Speaker's decision would be final and not capable of being challenged in any court. However, the minority judgment, authored by Justice J.S. Verma, as he then was, counters this by pointing out that this would stifle the MPs and MLAs and give too much unaccountable power to the Speaker. In this conversation, I spoke to Justice Venkatachaliah about his thinking in upholding the 10th schedule of the Constitution, what he makes of Justice Verma's dissenting judgment, and the state of democracy.
In law, everything depends on the context. Context is everything. If you had applied the same test that you applied some 30 years ago, the reasoning breaks down. Apparently irreconcilable elements in the arguments. The freedom of conscience, the constitutional right to dissent, and fall in line with the political discipline. It all depends on the level of maturity of a democracy. Democracy is something like moving towards the horizon. As you go, it recedes because new values, new equations, new inspirations occupy the minds of men. In that context, at a time when things were stabilizing, in the sense, no democracy can be called a stabilized democracy. The values are stabilized. The democratic urges and instincts are different. That's why Jefferson said the cure for ills of democracy is more democracy. And that was a time at which the context created some apprehensions in the minds of Democrats, those who entertain democratic spirit, that somewhere, sometime, somewhen, something is cracking down. And opportunism, political opportunism was overweighing on the values of democracy. That's the context in which the whole debate took place. I remember vividly the strong arguments of Ram Jethmalani. He said, freedom of conscience. I may disagree with my party and I may change over. If you resign, nobody objected, but you jumped over. That's where the instincts of a judge guide him, trained intuitions of a judge will tell him this is right in the context. I might not say that today, I might have said it with greater affirmation today. Yesterday I might not have done that. But to say that constitutional thinking is conditioned only by constancy, not by changing influence or changing circumstances, that may be not correct.
That's a very interesting point, sir. So if I've understood you, you have said that today you might take a completely different view on the 10th schedule. Because the way I perceive this issue, it is something which fundamentally affects the way our parliamentary democracy functions. But you mentioned in the context, one of the things which you highlighted was that the context at that time prompted you to take this approach. What particular features of that context made you feel that this is needed for our democracy?
Contemporary events unconsciously influence the mind of a judge. The events then, remember, of course that's a subsequent event, between 1995 and 2000 there were 3 parliamentary elections. And we began to doubt whether this is going to be some kind of a unstable democracy. This is exactly what Pandit Nehru and his team said. You will have universal adult franchise, the Republican pattern. I distinctly remember what the new American newspapers said. How can 330 million ignorant, uneducated people handle the sophistications of a parliamentary democracy? The same newspaper 60 years later, in I think 2007, said Indian democracy is robust but the rowdiest. 2007, I think Newsweek wrote an article, used the word, it's a robust democracy but the rowdiest. And the constitution makers of the men behind the philosophy of the Indian constitution had the right intuition, perhaps. If you see the debates in the Parliamentary Constitutional Assembly, it rose to spiritual heights. When there is a demand for reservation for the Muslims in elections and an assurance given on the part of the government that your interests are paramount, then they withdrew the amendment.
So on that point, if I could ask you to think back to that time when Kioto Holohan was being heard and decided, what was your feeling about where India was as a democracy, as a parliamentary democracy, right? I mean, people, of course, vote. And I make this point about parliamentary democracy for the simple reason that the government is answerable to Parliament. Unlike with the presidential democracy, where it is directly answerable to the people, in parliamentary democracy, the government is answerable to the people. Did you feel it was breaking down in some way?
No, Indian psyche was more resilient and more enduring than the sophisticated elite thing, the rustic reality about the values. I remember a story being circulated. How far it was true is another question. Because in the days of Holy Festival, street vendors used to sell milk laced with some intoxicant, local intoxicant, bhang. I am not able to boast to the authenticity of the story, but it was a story which inspired many of us to believing that we are part of a good society. A man was vending the milk laced with this bhang. An American with a lady companion came there and helped himself to a glass of this drink. And he asked the vendor to provide a glass to his lady friend. He said, I don't sell it to ladies. We don't know how they behave after that. He took out a high denomination currency, put it on the table and said, you take this and give it to her. I like this drink. He crumpled the currency in his fist, thrust it back into his pocket and said, you don't have enough money to buy my principles. This was the kind of stories that gave us confidence in the genius of the rustic mind. They stumble upon the correct decision at the crucial time. They stumble upon the correct decision, consciously or otherwise. There is something about the Indian masses. It's something which must go through that kind of thing.
No, that's right. And while it is very clear, and I say this, and a lot of people also say this, that the Indian democracy is not upheld by the middle class or the rich, but it is actually the poor masses who care the most about it. But the point I wanted to come to is the morality of the Indian legislator, the average MP or the MLA. Was there a sense at that time that, these guys are all crooks, we can't trust them?
You couldn't say that. There were very, very controversial assembly debates rose to spiritual heights. But the compulsions of electoral politics make them sway occasionally into a path which is not very delectable. You must understand this is not merely the voters were not demanding their part of the loot. Possibly a politician would be straightforward. It is two wrongs that make the right one. Both of them go on the wrong side of the street and there's no collision. They're what I call compensatory errors, not cumulative errors.
So you wouldn't say that maybe Mr. Ram Jethmalani was not entirely wrong?
He's not entirely wrong. It's an eminently arguable position and he pitched it on individual right. And we took a view of the collective sentience of the society.
That's a very interesting point to sort of see that this parliamentary democracy, as we understand it, also functions in the context of a certain society. But there was a dissent in this judgment. And this dissent was authored by Justice Verma. And Justice Verma, in my view, it was one of the most prophetic dissents, which said this is what will happen if we uphold the 10th Amendment. Did you get a chance to discuss this with him at some point about this judgment, why he dissented?
Before the judgment, yes. After the judgment, rarely. Because Verma and I never agreed on any of the full benches, constitutional bench sittings. He and I differed, and he was a very powerful mind. And a powerful mind is a threatening mind. You may be swayed away by the power of a powerful mind. We have to protect ourselves from it.
But he didn't try to convince you.
People don't know the way ordinary people, lawyers know that. There's animated discussion. In fact, in the corridor, to the annoyance of our ushers who take us to the court, they would have to wait with their silver maces, waiting for the judges to finish their never-ending debates. For half an hour, I've seen judges in the corridors talking animatedly about the positions they respectively held.
I think the key point that Justice Verma makes in his dissent was that the 10th schedule, he doesn't disagree that defection is a problem. He doesn't disagree that there needs to be perhaps some balance. But his contention in his dissent is that the 10th schedule makes the speaker partisan, that the speaker, by the person who's taking that decision, will risk becoming partisan. What was your reaction to that when he mentioned that particular point?
That is a stateable reality. But between the partisan speaker and the quality of political democracy, which would you rate higher? It's a question of choices. You can't, you had an opportunity not to make a choice at all, it would have been the best choice, but you have no choice.
So in the sense that you chose that we need to...
There's a lot of debate on the philosophy of constitutional choices. What was, for example, at some point of time, fixing working hours for the bakery workers was considered a violation of freedom of contract. Issuing paper currency was considered unconstitutional. There were days, and the starting point of the reverse gear started, I think, in that West Coast Hotels versus Parish in 1937. In 1962, that was affirmed with greater force in Ferguson versus Krupa. He said, we are tired of acting this super legislature. And the growth of a nation, the spiritual, moral, economic, and political growth of a society. Just imagine 20,000 years ago, the genetic man. We are descendants, genetic descendants of the 28,000-year-old genetic man. What kind of a man was he? What was he? He was afraid of wild beasts and the lightning. Today, see, a 5-year-old child, you give a handheld phone and it exhausts its potential in half an hour.
That is true, which is where I'll come back to the present context and I'll put you a little bit on the spot and say, if you had to think about the 10th schedule today, do you think it has worked as intended? Do you think it has failed? Or do you think things could have been worse without the 10th schedule?
I don't know. I don't have the stock of wisdom to sit in judgment over it. But my instinct is it's not worked as well as it was intended to work.
And maybe if another case came up today and say the 10th schedule, if Kioto Holohan was to be re-examined, would you say that perhaps maybe giving the speaker that much power was not the right idea or approach?
Might. I put my faith in the personality of the speaker a little too much. I went by the standards of Maulankar, and the others were not so great.
No, because that's an important point. And I think what is coming through, and at least being somebody who observes parliamentary debate and my colleagues who also observe parliamentary debates sort of feel that the speakers, not just in the context of defection, but in the wider context of how the House is run, the speaker's impartiality is being questioned, which I think was not so common in the days gone past.
Absolutely. That's why in English political tradition, the speaker's re-election is not contested at all. That's the place they gave to the speaker. And I think speakers have let themselves down in some occasions. They have let themselves and their high office down.
That's, I think, the very important takeaway that I think has come through from the debate over the 10th schedule and anti-defection law. And if the government were to, let's say, come to you today and say, Chief Justice, how do you think we should reframe the 10th schedule? Because you're an eminent constitutional lawyer, you have seen the development over the last 30, 40 years. Would you suggest any changes that you think would be necessary to the text of the 10th schedule?
Defection and split have caused a lot of problems. In defection is defection. Split is a defection. And if they can resign and contest the election, we may have to pay the price of a repeated cost of an election, but it's worth it. People have to have some kind of political morality about it. First thing, you must assume that democracy is not the best form of government. On the contrary, it is the worst form of government, except for all other systems tried.
As Churchill famously said.
See,
and this is where I draw the contrast between parliamentary democracy in the UK and in India. So much of what is done by convention there, we insist on rules here.
that is called the constitutional morality. Constitutional conventions are called the constitutional morality. We give so many different meanings to the word constitutional morality and things like that. It's a fixed term. It represents that No constitution works by itself. It requires the assistance, first the common law, second legislation, third is constitutional conventions. That is the constitutional morality. It's a very difficult thing, very difficult thing. Each country, each democracy has its own special problems of democracy. And democracy is like oxygen to life. Without it, can you imagine what would have happened to human societies? Justice makes democracy possible. International injustice makes democracy necessary.
And you have seen the evolution of India's parliamentary democracy over your entire life. And again, I'm asking in a very contextual sense. Do you see that it has strengthened? Do you see that there are weaknesses emerging in our parliamentary democracy?
Enormously, but strengths have also increased.
What are the strengths you would say?
Keeping the country together. Administration is mere not a reaction to problems. Administration is foreseeing possible events and try to remedy them. And that we have been able to do in a way which has enabled the country to be together linguistically and religious divisions, linguistic divisions. 1,000 ways in which a society can be divided. We can imagine it happens in this country. But how there is some substratum that supports coexistence of all these conflicting values. We don't know how to define it is very difficult. There is some sentience or ethos or call it what you want. There is something, some common ground on which impossibles are reconciled.
No, that's a very beautiful way to put it, that impossibles are reconciled in India. But I want to also ask about what do you see as the weaknesses going forward? What would future generations have to worry about in the context of India's democracy?
Loss of respect for settled rules. To seek to be wiser than the laws is the very thing by good laws forbidden. And we seek to be wiser than the laws to suit a particular situation. And that becomes a generality.
Even as the 10th schedule remains in the Constitution, defections have not come to a halt. Parties have found ever more creative, and some would say devious ways of avoiding disqualification of legislators who cross the aisle. Even though the 10th schedule has since been amended to try and limit the possibility of unethical defections further, governments continued to be destabilized by the unethical use of political defections. Perhaps, as Justice Venkatachaliah put it, we can do no more than to trust in the wisdom of the voter to check the behavior of their representatives. The next case is one which came up to the Supreme Court of India in somewhat bizarre and unusual circumstances. Abdul Rahim Antulay, then Chief Minister of Maharashtra, was accused of demanding money from builders for allocating cement to them out of turn. Cement was a controlled commodity in Maharashtra, and Antulay was accused of getting builders to pay to a trust set up by him in order to allocate cement out of turn and in contravention of state rules on the matter. P.B. Samant of the Socialist Party and R.S. Nayak of the BJP then approached the courts alleging corruption by Antulay, and when the Bombay High Court agreed, Antulay resigned as CM in 1982. When the special judge hearing the criminal case against Antulay dismissed it because there was no valid approval from the Speaker to prosecute Antulay, who was still an MLA, the complainant, R.S. Nayak, approached the Supreme Court. By a 5-judge bench order, the Supreme Court allowed the appeal and restored the criminal trial, but went further. It directed that the trial be conducted by a single judge of the Bombay High Court and transferred the pending criminal case against Antulay there. This was unusual since trials relating to corruption offences were supposed to be carried out by so-called special courts designated under the Criminal Laws Amendment Act of 1957, and the Bombay High Court was not designated as such under the law. Antulay made 2 further attempts to have these directions overturned in the Supreme Court, failing both times. As the criminal trial progressed, at the stage of framing charges, Antulay approached the Supreme Court once again, questioning some of the charges framed against him and the non-framing of charges against co-accused. This time, Antulay had better luck. The matter was referred to a 7-judge bench to see if the original 5-judge bench was justified in directing the trial to be carried out by a 7-judge bench. By a majority of 5-2, this time the Supreme Court held that the earlier directions were indeed incorrect in law and the matter was sent to a special judge for a fresh start. Justice Venkatachaliah dissented in this case, taking the view that the Supreme Court, even if it may have made a mistake in the earlier judgment, ought not to try and rectify the mistake in these proceedings. In this discussion, we explore why Justice Venkatachaliah took the position he did.
It is not a politically difficult issue. We made it difficult. There was a challenge. The Supreme Court said the trial will be conducted by a High Court judge instead of a session judge with a statutorily prescribed judicial authority for the adjudication. It is not pratiloma or anuloma, as we say. A lesser judge was nominated, a higher judge was nominated. Jurisprudence has always accepted the doctrine of de facto judge. Supposing a judge was over 62 and continued to work and later realized that he was not eligible to continue, he renders a judgment. Is that void? De facto doctrine. So the High Court judge was trying it. And secondly, that judgment which directed the High Court judge to try the case was challenged immediately in a writ petition. 5 judges said upheld it. So there is a judicial finality to it, whether it's a conflict between finality and correctness. If it's incorrect, the future cases will be governed by the changed law. But for that case, the law is frozen. And that's perhaps a narrow view, we may call it. That's, I said, it's a doctrine of finality. And Mirajkar had earlier decided you can't declare a judicial judgment as a nullity. English court dealt with it very dexterously. They said the doctrine nullity is a spectrum. Nawab Khan, as you said, Nawab Khan was straight to Gujarat, to 74 Supreme Court. Of course, Justice Krishna left. He took us up to the conclusion, but it's ultimately strike.
This is where there was a lot of controversy about the judgment. Why did the Supreme Court take it up? What was the need to set up a 7-judge bench? Were you part of the discussion then? What was the discourse around it?
We didn't go into that. We dealt with it as an issue, constitutional issue that came up. And there were 7 judges. And one judge said, well, we decide this will not be precedent. You can't say that. What you say is not because you say so, because the force of the constitutional provision.
And this is something which we have been seeing quite often of late, that judges say this is not precedent. To me, it seems a very unhealthy practice. I don't know what is your take on this. They deliver a judgment and say this is not precedent.
See, there are areas when it can't be precedent. I told you about a case in which a young boy was recommending to the government to remit this substantive part of the sentence, collect the fine as a symbol of punishment. Is it a precedent? Well, then how do you account for that observation? It's only can be accepted as the play the joints that Article 142 provided to you.
What prompted you to say, this is a judgment I want to dissent against? I suppose you saw the majority's judgment in Antulay's case. What was your thinking as to why you felt you wanted to dissent in this?
It simply looked to me that if 2 constitutional benches had decided, you may change the law, not reverse that decision. That's a fundamental principle or doctrine of precedent. If you change the law, it will govern the future cases. The previous cases are not undone. That's the principle of finality. But somebody said, finality is a good thing, but justice is a better. I quoted the sentence from an English judge who said, finality is a good thing, but justice is a better. But what is justice in the context? Anything which is violative of the constitutional direction is not justice, it's caprice.
That's a very important thing, that justice also has to be done within the framework of the Constitution. It is not an individual judge's opinion in a particular instance.
Yes, that's a healthy prescription for the judges.
Was there a sense, and again, this is going back to the occasion when this case was being heard, that maybe Antulay's privileged position as a politician of the ruling party and chief minister got him this extra level of scrutiny by the court?
I don't think so. There is a famous statement in the Ramayana, Arthanathantre buddhi nishitapi nashobhate khatanthi karyani duta panditamanina. However sharp your intellect, without a moral perception of means and ends, the intellect fails. The scornful impatience of the egoist wrecks his own mission. It's a beautiful statement. You contrive a dilemma where there is no scope for one. And subsequent events showed that even a judgment can be very vulnerable. No, Supreme Court directly convicted a person in the Supreme Court and substantive sentence, not under the Contempt of Court Act. For contempt punishment, the Contempt of Court Act does not exhaust the power of the court to punish for contempt. But the criminal trial, you convicted for a substantive sentence. And when the matter came up, they didn't declare that the previous judgment is a nullity. They merely said in a review and took an undertaking from the aggrieved person that he will not sue for compensation.
And this issue of the finality of judgments is something which has occupied discussion, and we are talking in the immediate context after the Supreme Court has extended the tenure of the Enforcement Directorate, the Director of the Enforcement Director, even though they have held his appointment to be illegal. Have you followed that case? What was your thought on it?
I have not followed that case. How it can be reconciled with doing complete justice under 142 is a debatable thing. We keep on debating such issues because there are occasions in which, as I told you, when I made a recommendation for remission of the sentence, how can you reconcile it with the philosophy you upheld that is a social protection legislation not to enforce strictly?
When you're talking about the individual rights of, let's say the example that you gave, that individual who, when he was 18, convicted of an offense, and you ask the government to remit, but is it a different calculation when it is relating to the government's powers? Do you think 142 itself should take different colors depending on who the party is before the court?
See, there are two views in the matter. There is one great aphorism, Latin maxim, which says, do justice, even heavens come down. But Clive Lewis, in his Remedies in Public Law, says, in the modern day complex administrative situations, this rule can't be applied universally. I upheld that passage in a judgment in the Supreme Court. I don't remember which. I said, in the complications of the model, a little more played, the joints is legitimate and necessary because it is not some kind of a administrative machine, it's not a logical machine. It's a big bulk of a machine which runs by greed and need. In law and society, when author said, is a behemoth which moves by need and greed. It has no contraptions and balances of this thing. It's a beautiful statement saying that governance is not a very logical thing. It runs by exigencies.
I fully understand that. And this is one of the core principles which I think has also informed how judicial review has addressed governmental action. This is where I think I come back to the Antulay case. At what point do you feel we have gone a little too far? We have given too much leeway. The play in the joints now threatens to break a constitutional principle. Was that something that played on your mind in the context of the Antulay case?
You are giving me more credit than I deserve in that case. And maybe when now you say that, I'm tempted to own it.
Please.
I went by strictly one thing. Why are we applying this principle which is not, the facts don't invoke the death sentence? I can understand the equations are different. Degrees of difference of degree makes a difference of kind. Not always, but occasions, difference of degree makes a difference of kind. And Antulay, I thought, was an extreme case of logic which was not sustainable. The Constitution says, the provision says, after the review, the judgment will be final. That finality is always subject to the doctrine that it's a nullity. But to say it's not a nullity, it needs only to be set aside to get rid of it. You can't ignore it. Then logically you must say you can't do this.
No, that's absolutely right. But after a few years after Antulay's case, we see the Supreme Court has, for the lack of a better word, invented the curative jurisdiction. And it invented this curative jurisdiction, seeing that there were...
Because they said their judgments can't be declared a nullity. There must be some way in which a nullity, real, in fact a nullity, which is not declared a nullity, should be got rid of. Hurrah's case, Hurrah doctrine.
Rupa Ashok Hurrah's case, in some sense, and you mentioned the example of the death penalty. I think recently in 2009-10, the Supreme Court was able to use the curative jurisdiction to ensure that injustice wasn't done in the context of a death penalty case where the court had wrongly given death penalty to some of the convicts. So you see that, I mean, at least as we see that, something like curative jurisdiction has in fact ensured substantive justice has taken place.
See, it must remind us constantly there's no absolutism in law. There's no absolutism in law. You can't, law and logic are sometimes at variance. Whenever there's a conflict between law and logic, law prevails.
Now that's a very beautiful way of putting it. And I think for the non-law person, this is sometimes very hard to reconcile. That is why I sort of wanted to have this discussion in this particular aspect, that it is not always that what is logical is what is...
It's difficult to deal with a very keen legal mind to answer these questions. And I am trying to face it.
That was Justice Venkatachaliah on his dissenting judgment in the Antulay case. In the end, Antulay was acquitted of all charges, though it took a decade to complete the process. The full saga of the Antulay case and the many litigations it spawned has been explored in a book by noted jurist Upendra Bakshi titled Liberty and Corruption, the Antulay Case and Beyond. In the next episode, we will look at Union Carbide Corporation versus Union of India and Dr. Ismail Faruqi versus Union of India, where the Supreme Court was asked to weigh in on the consequences of two of the most traumatic incidents in independent India's history, the Bhopal gas leak disaster and the demolition of the Babri Masjid. This episode was recorded at the Indian Institute of World Culture in Bengaluru, and I'd like to thank the team and staff at IIWC for making this possible. I'd also like to thank my colleague at Vidhi Bengaluru, Pratiksha Ulal, for her research help during this podcast.
You have been listening to BIC Talks by Bangalore International Centre. If you like what you heard, do follow us on social media. Keep up with our programming by signing up for our mailer on the website or leave us a review or rating on Apple Podcasts or iTunes. The crew that makes these podcasts possible is Gaurav Krishna and Ishan Gupta on sound supervision and production, with support from S. Sarunaraj and Raghu Tenkaila. Artwork is designed by Chandni Venkataraman of Crisscross Design Studio. Don't forget to subscribe to our channel on your favorite podcast platform. It can also be accessed on our website, bangaloreinternationalcentre.org. This is Lekha Naidu, signing off on behalf of everyone at BIC.